Now, getting back to the Miranda doctrine, I don't know whether Miranda was guilty or not. I've heard stories that he was a vicious criminal, a thug, and a killer, and he deserved to be put to death, and maybe that's true. I don't know. That's not the issue. The issue is rights. And where rights are involved, there can be no rule-making or legislation that would abrogate them. All right? Now pull that book out and turn to page 491. I'm going to use my own textbook because this binder that I use is like an old friend to me. I want you to turn over to page 491. I believe that's it. Let's see if I'm right. Turn to page 491. And right up there at the top of the page, as I recall, we're going to find where the Supreme Court of the United States, which in the United States of America is God. Now, whether you like it or not, that's the way it is. Because when you get to Washington, friend, and the Supreme Court rules against you, where, pray tell, did you intend to take your appeal next? To the World Court in The Hague? To the United Nations? When this court says this is the way it is, then that's the way it is. And the reason that I teach my students to go right to the Supreme Court and get the word right from the horse's mouth. We don't even waste time using the Southwest Reporter or the Idaho Supreme Court reports other than as collateral references to constitutional issues, because when it's all said and done, there isn't very much that's never been decided by the Supreme Court. They've already decided it all, or to my knowledge, just about all, and they've decided it about 10 times. And so when you get a Supreme Court decision, it isn't something new. It isn't something that the Supreme Court sat down and said, hey, fellows, let's sit down here and take a vote and see what kind of new law we're going to create today. Because that isn't the way it works. On this page 491, now read this statement, and if there's one that you want to memorize, friend, let me tell you, this is it. This is the most important piece of doctrine in this century. Where rights secured by the Constitution are involved, there can be no rule-making. And I don't care how many rules that sheriff's got out there. I don't care how many statutes the state of Idaho passes. I don't know of 5 statutes in the entire law section of the state of Idaho that applies to George Gordon. And it makes the police so mad when I tell them I'm a free man and those laws don't apply to me, they just come unglued. They just don't understand that. Slaves don't understand why it is that they have to obey certain laws, rules, regulations, and that there are other people that are exempt. Can you imagine this? Policeman comes up and he says, where's your driver's license? I don't have one. What do you mean you don't have one? No, just what I told you. Let me stipulate to the facts. I don't have a driver's license, the car's not registered, and I don't have any insurance, and I'm not required to. Title 49 applies to trade, commerce, business, and industry, operating for profit or gain on the public roads and interstate commerce. I'm not one of those. And watch them come unglued. Oh, they just get incensed. And then when they do that, let me tell you, the conversation always breaks down over logic, reason, and common sense. And I've had policemen say, you think you're better than all the rest of us, huh? Oh, wait a minute. Let me see if I understand your position, sir. I'm not sure I understand the street vernacular that you're using, but let me ask you a question. You seem to be somewhat angry at me, sir, because I don't have a driver's license. And I know that you're probably right and that I'm probably wrong, and I probably am one of those persons required to have one, and I'm probably just deceived and don't understand the law. However, if I may, sir, ask you a question, did you sign up for the draft? There'll usually be a little pause right there. Well, no, of course I didn't sign up to the draft. I'm not required to do that. Oh, okay. I just wanted to ask you the question. Let me ask you another one. Policemen are trained to ask questions. And they're also trained to answer questions. They've all been to the government schools. You ask him what his Social Security number is, he'll tell you. Whether or not you're going to send him a check, ask him what his date of birth is, and he'll tell you exactly. And he's not even expecting you to send him a cake. When people ask me what my date of birth is, I ask them, are you going to send me a cake? When they want to know, what's your Social Security number? Oh, are you an administrator of Social Security? Huh? Yeah, you going to send me a check or something? You want to know my number? I just wondered, Listen to this one. Now the guy, he's standing there in a little bit of bewilderment and awe, because you're not screaming at the top of your lungs incoherently, babble and baloney. Ask him this one. Sir, let me ask you a question. Did you sign up as a resident alien in the month of January? Sign up as a resident alien? No. Oh, let me ask you this. Why? Well, I'm a natural-born citizen. I don't have to do that. Oh. Let me ask you another question. Is it your position then that those two laws don't apply to you, and that's why you didn't fulfill the terms of specific performance? And watch the conversation just turn to mush. You see, you've just asked the guy the very question to which he has put to you. Do you think you're better than everybody else because you didn't sign up as a resident alien? Let me ask you this. Could you sign up as a resident alien? Is there some reason why you couldn't? I don't know of any. Go down to your post office and take the form and fill it out and put down there, George Gordon, where were you born? London, England. And fill it out and sign it and send it in and see what happens to you. Now all the Department of Immigration and Naturalization needs is a show cause order as to why you shouldn't be deported. They don't need to prove that you're an alien. You've already admitted that. Now do you see, what I'm telling you is that not all laws apply to all persons at all times. Now policemen, for some reason, have a real hard time understanding that. I've never talked to one yet that could hold an intelligent conversation. If you know of one, write and let me know, would you? Because I'd like to know who this guy is. Policemen seem to be the most incompetent and the most illiterate of persons who can be hired guns used by cities and state governments to enforce the king's statutes. I call them goons. Now, I'm not, if you're a policeman and you're listening to me on this tape, don't get offended. There may be some people out there who have badges and guns on their hips who are not goons. I just don't know of any. That's my position in life. And I've had a lot of experience. So if you're one of those, you write and let me know. And I'm happy if you're a policeman or a government official and you're trying to learn the law, because remember, I'm not teaching you something from 1 Gordon 14:4. It isn't even important that I believe what I'm telling you. It doesn't change anything. It's like the Ten Commandments. It isn't imperative or even important that you believe it. And the Supreme Court is the highest court in the land, and I don't even care whether you agree with this statement or not. It's not important. They said that where rights secured by the Constitution are involved, there can be no rulemaking or legislation that would abrogate them. Now let me give you a reading lesson. If you'll take a look at those words, if it says where rights secured by the Constitution are involved, well, what about this? Where laws that are not secured by the Constitution are involved, there can be rulemaking or legislation. Whenever you got a coin, or whenever you have a coin, don't you have two sides to it? All right, let's turn to the front of Miranda, and let's take a look at what the Supreme Court of the United States has to say. All kidding aside now, no matter who you are, don't want you to get offended over here. Let's take a look at what's going to happen to you when you get into Washington, D.C., and you're going to argue the Fourth, the Fifth Amendment, or you're going to argue some constitutional point of law, because the Supreme Court doesn't change, no matter what you might think. They're not changing with every wind of doctrine. Miranda is not a new doctrine. Miranda came from John Wilborn in 1637, and we're going to see that in the Miranda case as you read through it, where the Supreme Court goes back to the old common law in England, to the United States. 1637, is just a few years this side of the landing of the Pilgrims. And the Fifth Amendment, which was a statute in England, has been clothed with the impregnability of the Constitution in our country. And this Fifth Amendment is the only thing that separates you from the Polish dictatorship. And furthermore, in this country, if you can't use this Fifth Amendment, you can't have it. Now, how do you like that? I would guesstimate that probably 99% of all the citizens of America have no more rights, no more privileges or immunities than the average Pole or Czech. Because, first of all, they don't know how to claim them, and they don't even know that they have them. Go ask your average friend or neighbor and just tell him, well, now, what are your Fifth Amendment rights? Just what is entailed with this Fifth Amendment? And if they know anything at all, they'll say, well, it's a loophole in the law for criminals to get off. That's what they think it is. The truth of the matter is, it's an absolutely vital right that you have, the right to remain silent and not incriminate yourself, and that includes fingerprints, that includes written documentation to the IRS. You don't have to produce one shred of evidence in a criminal matter for your government to prosecute you. And when you take that right away from the citizen, the police then move right in and begin to extract confessions, admissions, and will take whatever evidence they need to convict you. Oh, would they do that? Gosh, do you mean to tell me that the police would use lighted cigarette butts, false witnesses? Do you think the police for a moment would lie about a citizen? Would try to trick or in some way entrap him into guilt or a guilty plea or a guilty statement in order to put him in prison, even if he was innocent? Okay? Let's take a look at what your Supreme Court uncovered about police practices and police tactics. When we start off at page 436, that's your first page, you'll notice it says syllabus, S-Y-L-L-A-B-U-S. What that is the editor's comments, just like the Reader's Digest. It's the editor's comments about what this case is about. And it has no more weight, veracity, or authority in law than does the Reader's Digest in law. So the syllabus is simply a guide. Never quote the syllabus when you're writing a brief or a motion, because that syllabus has no factual foundation in law. What you do is go to the Supreme Court and you quote the judge that said it. And make sure that you're on the majority opinion when you quote it. Because if you're quoting dicta, that is, statements from the minority opinion, you're out to lunch. And if you're quoting dicta out of the majority opinion, you better be able to label that as dicta, and you'd better learn how to stay on point, and we're going to cover that as we go through this. Now, this lesson is the jailhouse scene, so I'm not going to cover that today in this lesson. But I'm going to teach you what dicta is, and I'm going to teach you how to stay on point. And let me tell you that in 5 years, I've only met one lawyer that could sit down for an hour in a conversation and stay on point. One. So we flip over here a little bit, and we're going to come to a position, I think it's on page, here we go, page 436. Down at the very bottom it says, Mr. Chief Justice Warren delivered the opinion of the court. This case came down 5-4. Split decision. Came down for this reason. It wasn't that the minority judges didn't believe in the Fifth Amendment or the Fifth Amendment protection. What they were concerned about is if we take this approach and tell every prisoner that he has the right to remain silent, they will. And if that happens, we won't be able to get as many convictions. In the back of this case, you're going to read the dissenting opinions of the 4 judges. And here's what they told us. They were afraid that since 90% of all convictions in the United States come down from admissions and confessions. That's right, 90%. You know, if a person could just keep his mouth shut, he'd have a 90% chance of winning, wouldn't he? Yeah, 90% of all admissions or 90% of all convictions come from admissions and confessions. Now do you see why the police want confessions and admissions? Isn't it easier to beat the confession out of the guy that's in jail than it is to go out and pound the pavement, knock on doors, and gather evidence and information from witnesses? Well, I know if I was a policeman, I'd find it a whole lot more convenient if I've got somebody that I think is guilty in the jail. Let's just work him over a little bit and let's talk to him and let's get his confession. Well, if you did that, you'd have a police-state tyranny that you wouldn't believe. You'd have the kind of police-state tyranny they have in Russia. They just haul a guy in off the street, and about 5 days later, when they've got his confession and admission, then we're ready to go to trial. All right, well, I don't want to be subjected to that, and I don't think you do either once you understand what the police do. And remember, the police are doing this today. They did it yesterday, and they're going to do it tomorrow. Everything that we're going to read in here is being done right now, and it's going to be done to you unless you know how to assert your rights, and you know how that jailhouse scene comes down, and you know how to demand your rights and immunities right there in front of those officers. So Chief Justice Warren starts off like this. Page 439, bottom of the page. The cases before us raise questions which go to the roots of our concepts of American criminal jurisprudence. The restraints society must observe, consistent with the federal Constitution, in prosecuting individuals for crime. More specifically, we deal with the admissibility of statements obtained from an individual who is subjected to custodial police interrogation, and the necessity for procedures which assure that the individual is accorded his privilege under the Fifth Amendment to the Constitution not to be compelled to incriminate himself. And he goes on. That's the subject matter of the case. Turn over now with me to page 441, and you'll see an underlining there. I'm going to run through these underlinings. You can run through this case and read it for yourself. And be sure to read the minority opinion, because, you know, if I was one of the judges and had to make this decision, it would have been a tough decision for me to make. Because when you read the dissenting justices' opinions with the majority justices' opinions, you know, then that puts you on the hot seat and you have to decide, well, what would I have done? And it also tells you another thing, you know, that when the Supreme Court decides a case, there is some honest difference of opinion as to how law should be applied, not interpreted. The Supreme Court doesn't interpret law. The Supreme Court applies the law. Interpretation comes from your executive branch of government. And I'll get into that a little later. But let's cover this from page 441, the underlining. Allegations that modern criminal investigation can compensate for the lack of a confession or admission in every criminal case is totally absurd. That comes from some books that the police use. Their position, the police have taken the position here, that you've got to have confessions and admissions. Even with modern fingerprinting and computers and sophisticated laboratory techniques like Quincy, cannot make up for admissions and confessions. Well, now the police seem to be at loggerheads with the Constitution of the United States, because let me tell you, the Constitution of the United States is emphatic, and the Supreme Court is emphatic, and has been for some 800 years since Magna Carta. And that is, you cannot compel the defendant to aid the prosecutor in gaining conviction. Now, in almost every case, 90% of them, the defendant makes the admissions and confessions with which he may then be convicted. And there's nothing wrong with a guy. If he wants to confess, that's terrific. Let him confess. But if you don't want to confess, can you be compelled to against your will and over your objection? Now flip over to page 442, wherein Chief Justice Warren continues. He says, we have undertaken a thorough re-examination of the Escobedo decision and the principles that it announced, and we reaffirm it. What's Miranda then? Miranda is simply a confirmation of Escobedo. And Escobedo was decided a couple of years before. Pull that case out, Escobedo versus Illinois, I believe it was, and take a look at Escobedo and find out he had a Fifth Amendment issue that was argued in front of the Supreme Court. So you're beginning to see here the Supreme Court simply goes back to another case and say, yeah, we've reviewed it and we just reaffirm it. This shouldn't be called the Miranda warning. It should be called the Escobedo warning, or whatever warning that came before the Escobedo case, because when the Supreme Court decided Escobedo, what did they do? They went back to some other previous cases. Now you're going to say, well, somewhere along the line somebody had to make the first decision on the Fifth Amendment. Yeah, that's right. Why don't you tell me where it was, because I don't know. I don't know where the first decision came from. I saw John Wilborn mentioned in here in 1637. Where do you suppose they got the decision in the Wilborn case? Well, they probably went back 200 years and pulled it out of there, and they went back to Magna Carta and before. I can trace the common law clear back to Mount Sinai. The Ten Commandments are the foundation of the common law, and gold and silver is the substance that supports the common law. The first people to have the common law were the 12 tribes of Israel when they crossed the Jordan River. It was a Statutory law that you couldn't move a man's boundary marker. Well, if you couldn't move a man's boundary marker and there was a statute, there was a law that said thou shalt not do that, it shows that those people then held property, didn't they? Well, if they held property, and it was such an absolute allodium, freehold, title to property that you couldn't even sell the property, that if that property belonged to the Gordons, and Gordon was sent into captivity or into slavery for whatever reason, there was a thing called the year of release, and the property had to be handed back to the Gordons again. And furthermore, if Gordon sold the property in the Jubilee year, in the 50th year, it had to be given back to the Gordon family, even if Gordon was dead and buried and long antecedent to this issue. So this isn't something new and unique. The common law is our Constitution. Equity under the common law is the king's statutes designed to exact tax and profit for the king and or the government. So now we've got our Supreme Court under our Constitution, which has given us property rights and sovereignty. You got 220 million sovereigns in this country. In England, you got one, Queen Elizabeth. She's a sovereign. She owns everything there. She's a sovereign, and everybody acts in privilege under her sovereignty. In the United States, we changed that. We said, there will be no titles of nobility. Article 1, Section 10 again. Now you begin to see sovereignty, the common law, the Constitution, and this Fifth Amendment right are so indelibly tied to the Ten Commandments and the common law which originated at Mount Sinai, and with the Israelites who had property rights which substantiated the common law and made it function, has come to us down through the ages and through all kinds of captivities and all kinds of people, and was resurrected again at Runningmead with King John when the Lords went out and said, tell you what we're going to do, John, we're going to reinstitute common law here. We're going to sign a new contract with you, and if you don't agree with it, we'll kill you, and we'll get somebody else to sign the contract. And King John seemed to see it their way and signed the contract. And the common law was reinstituted. I contend that the Fifth Amendment and the common law came from the tribes of Israel about 1000 B.C. to 1400 B.C., which I think is about the time Moses went into what's now referred to as the Promised Land, or the tribes of Israel, or this land of Israel. So here we see then the Supreme Court is simply saying, I'm reaffirming. We, the Supreme Court, we're reaffirming Escobedo. Take a look at Escobedo and see if what I'm telling you isn't true. In Escobedo, they're going to say, we're simply reaffirming the case that we saw before. Go look at that case. And we're reaffirming that decision and reaffirming and reaffirming and reaffirming, and it just goes on and on. All right? That case was but an explication of basic rights that are enshrined in our Constitution, that no person shall be compelled in any criminal case to be a witness against himself. And that, get this, and that the accused shall have the assistance of counsel. Wait till we get into counsel. Let me tell you a story. I've never been thrown in jail and given counsel. Have you? Watch what happens when you're thrown in jail. They'll bring you a little piece of paper over there and they'll say, here, let me read you your rights. And they'll sit there and they'll read you about 5 or 6 of your rights. And they'll say, do you understand all of your rights? And the average guy says, yeah, I understand. Here, sign here. And the guy signs it, right? You know how many rights you have? Well, in Idaho, based upon the Idaho Rules of Civil Procedure and the Idaho Rules of Criminal Procedure, we counted over 800. Yeah, that's right. 800 rights. And this policeman comes up and he'll ask you, do you understand all of your rights? When they ask me that question, no, I don't. Do you read and write the English language, dummy? Yes, I do. Well, what is it about these rights you don't understand? I don't understand the language that you're using because you asked me if I understood all of my rights, but you only read me 6. Is it your position that there is a total of 6 rights and that's all? Or could there be some more? Reason, logic, and common sense again. I'll tell you, if you're not in jail having fun, you're not doing it right. Jail is one of the more the more fun experiences of the pro se litigant's journey down the judicial trail to recovering his rights and recovering his freedom. Oh, I'm telling you, you're going to have a riot in there. So they'll say, well, now, wait a minute. Excuse me, officer. Let me ask you a question here. It says right here at the top, it says, every accused has the right to counsel. Is that true? Do I have the right to counsel? And they'll kind of look at you pathetically like, you poor dumb dope. And they'll say, yeah, that's right, dummy. Oh, okay. Good. Would you get me some counsel right now because you just told me I've got a right to counsel and I want him right now because I don't want to sign this unless I have counsel to advise me? Let me tell you, friends, the conversation is going to turn to mush right there. Here's this policeman telling you you've got a right, and the first time you demand the right that he tells you got, he'll sit there and tell you can't have it. Now do you see why I'm telling you that the police are generally the type people who don't seem to be able to read and write and understand? They act like they're all Marine sergeants, as far as I can tell. I haven't been in the Marines, and if you're a Marine sergeant, don't let me offend you there, but all I'm telling you is that these guys that are out here in the Ada County Jail they all look like Marines, boy. I'm telling you, these guys are like gorillas, and they got tattoos on their arms, and they're big, and they're tough, and they're dumb. And that's a fact. All right, so you've got to have the right to the assistance of counsel. Now, the difference between a lawyer and counsel is monumental. And that's where you need to take up the counsel issue and the counsel briefs and read and study the differences between counsel and lawyer. I don't ever want a lawyer. Boy, when I get in the courtroom and the judge says to me, do you want counsel, Mr. Gordon? Yeah, that's right, Your Honor. I want counsel of my choice, pursuant to the Sixth Amendment guarantee into the Bill of Rights. Okay, are you indigent? No. Do you want me to appoint a lawyer for you? No. Are you going to secure a lawyer? No. And they'll just come unglued. Well, but because you see, because of Argersinger versus Hamlin Sheriff, you cannot put a man in jail unless he has counsel. Understand that? And here's your Supreme Court telling you not only can't you beat the confession out of him, you got to have counsel there with him. And my position is, if it's good for killers and muggers and rapists and robbers and thieves, it's good for people just like me. And I'm going to use my Fifth Amendment right and my Sixth Amendment right to counsel, and I'm going to use it to the hilt. And if you deny it to me, then I'm going to prosecute you criminally and civilly. That's my position in life. All right, now let's read on a little bit. See how much fun you can have at this? Let's turn to page 443. No, that's page 443. Follow along. Down the middle, underline. So deeply did the inequities of the ancient system impress themselves upon the minds of the American colonists that the states with one accord made a denial of the right to question an accused person a part of their fundamental law, so that a maxim, which in England was a mere rule of evidence, became clothed in this country with the impregnability of a constitutional enactment. And you'll notice that says Brown versus Walker, 161 U.S., page 591, 1896. Did you think that this court just read some book like Reader's Digest and made the decision? That statement came out of Brown versus Walker. So here's the Warren Court telling you that so deeply was this principle of confessions being compelled out of a defendant that in England, which was a mere statute, is now clothed with the impregnability of a constitutional amendment. That isn't new law that the Warren Court came up with. If you're going to get mad at the Warren Court, don't get mad at Warren. He's not the dummy that thought this up. He's probably sitting there saying, I'm not even smart enough to figure that out, so I'm just going to go back to 1896 and pull that statement out of Brown versus Walker. You begin to see that the question of the Fifth Amendment was already decided in 1896. And if you went back to Walker, remember what I told you? You'll find that it was decided before then and before then and before then. And you carry it back, and pretty soon you're going to get your feet wet walking across the Jordan River. That's the way the Fifth Amendment works. Let's go on. In stating the obligation of the judiciary to apply these constitutional rights, this court declared in Weems versus U.S. in 1910 These guys, some of them weren't even alive in 1910, and they're going back to 1910 to find out how does the Fifth Amendment work. In stating the obligation of that judiciary. What's the judiciary? It's the third co-equal branch of government. That judicial power, that courtroom, has the same power as the President of the United States, and you as a citizen, Joe Blow, on the streets of Philadelphia can walk into a courtroom and exercise all of the power of a sovereign. Greater power than the President of the United States, because the President is not a sovereign, he's a subject. He doesn't have the power that a free man has. He's a public servant, remember? Remember lesson 1? Remember status? Yeah, that's right. And so here's a free man who can go into the courtroom, stake out about 9 square feet and say, Your Honor, let me tell you my position. And tap the power of the entire third branch of government in his behalf. When you get into that courtroom, friend, you have reduced the size of government, like the IRS with their thousands of agents and their hundreds of employees and their bureaucrats and all of their computers and all of their legal talent and knowledge and laws and everything they know. You've reduced the fools to the status of one man sitting over there at the prosecutor's table and one pro se citizen sovereign sitting at the defendant's table to argue law. You see how that works? Now all of a sudden, it isn't you against the IRS or some megalithic bureaucratic agency. It's just one-on-one, you against him. Can you whip him or not? Because if you can whip him, you can whip the IRS. If you can whip him, you can whip OSHA. Now, your status is going to be very important to you. Admissions and confessions. Procedure is going to be very important to you. And this Fifth Amendment is going to be very important to you. Going on, our contemplation, this is the Warren Court now, our contemplation cannot be only of what has been, but of what may be. Under any other rule, a constitution would indeed be as easy of application as it would be deficient in efficacy and power. Its general principles would have little value and be converted by precedent into impotent and lifeless formulas. Your Supreme Court is telling you then in street language that the Constitution is a superior document to the police regulations of Sheriff Palmer or the police regulations espoused by your legislature or the procedures and police regulations of Congress or anything else. The Constitution is the supreme law of the land. Now, how do you use that? That's like having a gun and no bullets. I mean, you've either got to have it all or you're not going to have anything. You give the guy the gun and you give him the bullets, and now he doesn't know how to load it and he doesn't know how to use it. Fifth Amendment is a powerful weapon, and you need to know how to use it. And this has been recognized. The meaning and vitality of the Constitution have developed against narrow and restrictive construction. Well, let me tell you, there's a lot of people out there trying to interpret the Constitution. Every policeman you come in contact with is out there telling you, that's a bunch of baloney. And then trying to explain and expound law to you while you're in the jail, and they lie to you, and they give you false legal information, and deny you your rights, privileges, and immunities, and most people fall for it and make admissions and confessions not knowing how to use it. But let me tell you, the Supreme Court knows how to use the Fifth Amendment. The Supreme Court knows how to tell you how to use it. That Fifth Amendment and its construction is upon narrow and restrictive construction, not broad application. The police are then chained down by the chains of the Constitution when you know how to use it. There was the spirit in which we delineated in meaningful language the manner in which the constitutional rights of the individual could be enforced against overzealous police practices. See what your problem is? Overzealous police practices. It was necessary in Escobedo, as here, to ensure that what was proclaimed in the Constitution had not become but a form of words. In other words, the police, they'll mouth words. They'll say, you've got the right to counsel. And then when you say, terrific, go get one for me, Conversation turns to mush. Never had the police ever go out and say, oh, excuse me, Mr. Gordon, telephone's right over there, go ahead and call your counsel, and when he gets in here, then we'll take up the conversation. When that happens, let me know, would you? I haven't seen that happen yet. And then they quoted the Silverthorne Lumber Company, which is one of the exclusionary rule cases in 1920. In the hands of government officials, and it is in this spirit consistent with our role as judges that we adhere to the principles of Escobedo today. All right? Now, down in the middle of the page, it says, by custodial interrogation. I don't know if it's underlined in your book. Follow along with me. By custodial interrogation, that's right in the center of page 444, we mean questioning initiated by law enforcement officers. Initiated by. Don't get confused now. If you initiate the questioning and you make admissions and confessions, they may be used against you. It's when that policeman walks up in a custodial interrogation. What happens when the policeman stops you with a traffic ticket? He comes up to the window and he says, I want to see your driver's license, registration, proof of insurance. Excuse me, officer, am I free to go? No, he's going to tell you. Oh, then I must be in custody. No, you're not in custody. This is a routine traffic stop. Let me see if I understand this, officer. You've stopped me, and you're asking me questions. Is that right? Boy, watch this conversation turn to mush. I want to see your driver's license, registration, and proof of insurance. No, now, because they don't have any intelligent response, they have to resort to intimidation, threats, and commands. They learned that in basic training when they were in the Marines. Who has initiated this encounter? Did you turn your spotlight on and stop the policeman? Or did he stop you with his spotlights to make this intrusion into your life? When it's initiated then by the law enforcement officer, now let's go on, after a person has been taken into custody, where did the custody come in? It came in just as soon as you looked out the window and said, am I free to go? When he says, yeah. Oh, okay, thanks, officer, goodbye, and you close the window and go down the road. When that happens, let me know, would you? When you're taken into custody or otherwise deprived of his freedom of action in any significant way. Well, let me ask you this. Here you are, you're pulled over to the curb, and the policeman's standing there at your window, and his lights are on in his patrol car, and you just ask him, am I free to go? And he tells you no. Well, that looks like your freedom of action has been deprived, is their word. You have been deprived of your freedom of action in a significant way, haven't you? You see where your Fifth Amendment right comes right in? Right there. Every time. Right there. Exclusionary, excuse me, officer, while I pull the exclusionary rule down between us. I want protection from my government. I don't have to tell the officer whether or not I've got a driver's license. If I tell him, no, I don't have a driver's license, isn't that a confession and admission? Aren't we in a police custody interrogation type situation with him initiating the interrogation? Well, what did your Supreme Court say? It says, oh, if you're deprived of your freedom of action in any significant way, then, and if the interrogation is initiated by the policeman, then you better shut your mouth, right? Rule 1. Rule 1 then is, keep quiet, don't say anything, and shut up! Because 90% of all convictions come from admissions and confessions, as we're going to learn later. You don't want to talk. Now, once you become experienced at this, then you may want to stipulate to the facts, and you may want to lay other foundation of law at the scene of the crime. So don't get confused with me telling you that. Sometimes I tell the officer and stipulate to the facts, officer, I don't have a driver's license, I don't have any registration, this car is not insured and it's not engaged in interstate commerce, Title 49 doesn't apply, and blah, 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 and I may go on and stipulate to the facts because I want to put him on the witness stand to ask him, well, didn't I tell you plainly what my status was? But if you've got a driver's license, and, here you are, maybe you are a slave. Maybe you don't want to make any admissions and confessions. Well, if you don't want to, now's the time to keep your mouth shut. Going down a little bit further, I've underlined these in my book, and you may want to underline these too. Down toward the bottom where it says prior to any questioning. Now listen to this. This is your Supreme Court speaking to you now, telling you, the citizen, the victim of overzealous police practices. Now, you know, there's going to be a lot of policemen watching this tape, and they're going to say, well, I'm not overzealous. Okay, terrific. All I'm telling you is that there are one or two policemen out there in the United States of America that can sometimes, from time to time, get overzealous and deprive people of their civil and constitutional rights, and I'm very happy that you're not one of them. What I want to do is to teach policemen and prosecutors and judges and other public and government officials that there is a status of person out here called the free man, the natural citizen, person who has his rights under the common law and hasn't given them up for privilege in some type of regulated industry under the police powers. That's what I want you to understand. So if you're a policeman and you stop me and you ask me what my name is and I tell you, sir, let me ask you a question, you'll know right away who you're talking to. Because you know, what's your name? My response is, who wants to know? And why? Pursuant to Brown versus Texas in 1978, and I'm not really sure I want to tell you. I mean, after all, if I'm an escaped robber from Leavenworth and some policeman walks up and says, hey, what's your name? Did you think that I want to sit there and tell him, yeah, I'm Joe Dillinger, and I'm John's brother, and I just escaped from Leavenworth? I don't have to make any admissions like that, and I don't intend to. And anybody that would's got to be bombed out of his gourd on some kind of acid. All right? So now let's get down to the bottom of the page and watch this. Now, prior to any questioning, the person must be warned that he has a right to remain silent, that any statement he does make may be used as evidence against him, and that he has the right to the presence of an attorney either retained or appointed. Well, I didn't write that. Now, if you're a policeman or if you're a government official and you seem to think for some reason that this is bad, wicked, terrible, and awful, and that the Supreme Court says, I don't care. You can have whatever opinion you want. What I'm telling you is that this is the state of the law. There isn't any other appeal. Got that? There's no other appeal. This is the law. This is the way it is. Read me my rights and tell me about it, and then go get my counsel for me, would you? And then once we get my counsel, then we can talk about whether or not I want to make any further statements. And then stop beating me up and stealing my fingerprints and committing violations of law, because if and when you do that to me, I'm going to see you in the courtroom, and I'm going to put you on the witness stand, and I'm going to hang you. Now, and I'm going to teach thousands of other people across the land how to do the same thing, and that's why we're watching this tape. Let's turn over to page 445, and let's take a look at another little bit of wisdom and understanding from our Supreme Court. Down at the bottom of the page. An understanding of the nature and setting of this in-custody interrogation is essential to our decisions today. The difficulty in depicting what transpires at such interrogations stems from the fact that in this country they have largely taken place incommunicado. From extensive factual studies undertaken in the early 1930s, including the famous Wickersham Report to Congress by a presidential commission, it is clear that police violence and the third degree flourished at that time. Let me tell you, friends, police violence and the third degree flourish at this time. Of manufacturers, then they want a open shop or a right to work bill. You see, these people want certain legislation to benefit them financially. I don't know of any other exceptions. There may be some, but listen, 99% of the time it's going to be money-oriented. All right, so now, the legislature, then, what are they there for? They're just there to represent the will of the masses of people. You know, if they think that 51% of the people want something, or that 51% of the people don't object to something, they'll pass whatever law you want. A lot of those legislators aren't lawyers, they're not constitutionalists, they're just laymen. They haven't got any idea about law, and they couldn't go in the courtroom and argue a case any better than you could. Our legislators here get caught for drunk driving, and they just go in and plead guilty and walk out, and the fools are up here passing drunk driving legislation. You'd think, if nothing else, they'd think of their own self-interest and say, I'm not voting for something that's going to come down on me and create a police state around my own little world. All right? That'd be my common sense reaction to that. So, the word all persons does not mean every last citizen in the United States. It only means all persons who come under the purview of the enabling statute of the particular title that's in question or that is the subject matter of the law. That's all that means. Let me illustrate that to you. Did you sign up for the draft? Well, look at me. I didn't. Did you sign up as a resident alien? I didn't. Now, what if the policeman comes up to me and says, "Sir, did you sign up for the draft? Did you sign up in January as a resident alien? Are you violating Title 42, Section 1927 of the U.S. Code and Section 27 of the Idaho Code, Section 2204? Let me see, officer. First of all, let me put up the exclusionary rule here. I don't want to answer your questions. Am I in custody? No. Goodbye, I'm leaving, and I'll walk away. Yes, you're in custody. You can't leave. Oh, well, if I'm in custody, then I don't want to answer your questions. I demand counsel present. And what's your probable cause for making this intrusion into my life? I'm going to hang him right there. I'm not even going to talk to him about the subject. I don't have to talk to policemen about whether or not I'm an alien or a resident alien or whether I'm born in Brazil or born in California. It's not relevant. I don't answer questions. Let's talk about Brown versus Texas. You know, when we get to Brown versus Texas, do people have to identify themselves? Absolutely not. I don't have to tell you my name or anything about me at any time. You have to have probable cause to believe that I am something other than. You, the policeman, have to have probable cause to believe I'm a convict or that I'm escaped from jail or that I'm a resident alien or something else. I don't have to talk to you at all. I don't even have to answer your question. What's your name? But as a matter of practical fact, I always want to put the exclusionary rule up and make those three demands. Counsel, I don't want to talk, and what's your probable cause? Because that establishes this exclusionary rule. Now, whatever he gains from me is illegal and unlawful, and I can have it excluded from evidence. Now he can't use it against me. Everything that you say can and will be used against you. And put another way, all of the evidence that the government uses against you will be furnished by you.